Today, we will hear arguments in the case New York Rifle and Pistol Association versus Brune. Counselors, please introduce yourselves.
I'm Win Conger of the Baldwin School.
I'm Lighthouse Wu of the Baldwin School.
And today we will be representing the petitioners. All right.
Thank you. Proceed.
Thank you. Mr. Chief Justice, and may it please the court. In the case of the New York Rifle and Pistol Association versus Brune, myself, Win Conger, and my co-counsel Lighthouse Wu will be representing the petitioners in today's case. The issue presented today is whether or not the Second Amendment allows the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense. As the petitioners, we affirm the question, and that a law-abiding person may carry it outside the home under the protection of the Second Amendment. Under Heller, the court ruled that the language and the intent of the Second Amendment principally guarantee the individual right to possess and carry weapons in case of confrontation to all citizens of the United States. A pre-existing right, which, like the First and Fourth Amendment, has long been codified under the Constitution's jurisdiction through the Second Amendment's legislation, even before the time of the founding. To keep and bear arms in the name of self-defense is synonymous with the fundamental right of the people, and at its core, the Second Amendment has always enshrined this right. However, the New York For Cause law clearly violates this constitutional liberty, and therefore must be struck down. While it's not strictly a ban on arms ownership, New York Penal Law 400, the Sullivan Law, nevertheless imposes undue burden on the individuals who seek to exercise their protected right. Despite both petitioners being of good moral character without criminal history, New York's restrictive carry regime directly burdens and even restricts their exercise of the constitutional right as firearm possession as a means of self-defense, thus violating their individual right to self-defense under the Second Amendment. Under Heller, every citizen is entitled to individual right to use their arms for legitimate and lawful purposes, such as self-defense within the home. Therefore, under Heller's precedent, petitioner's national coach, along with all law-abiding citizens of America, are entitled to the carry of arms both within and outside the home under their inalienable right to self-defense. It is nonsensical to claim that the people's right to self-defense is no longer protected once one steps out of over their threshold and fundamentally fails constitutional muster under Heller's precedent. Because of the aforementioned reasons, we ask the court to rule that the states cannot deny a law-abiding person a license to carry a handgun outside the home under the Second Amendment's protection and this court's precedent. Thank you.
Thank you. Could you provide a brief recitation of the facts?
Yes, in September 2040, both petitioners simultaneously applied for and then were later denied a concealed carry license on the basis of New York Penal Law 400, Sullivan, that neither of them had provided what their licensing officers subjectively deemed a proper cause. Both petitioners have extensive firearm experience and training. Neither had any criminal history of note, and both were motivated to possess arms inherently in the name of self-defense. Nash in particular, petitioner Nash in particular, was threatened by his recent robbery within his neighborhood, and feeling unsafe in the area, wanted to secure his safety both within and outside of his home. Under New York standard, no license shall be issued or renewed unless the officer in question finds the applicant to exhibit good moral character and lack a criminal or mental illness record, and no good cause existed for the denial of the license. But despite fully meeting all those requirements, because the petitioner's motivations to conceal carry for self-defense were deemed insufficient to merit license, petitioners were prevented from exercising their Second Amendment right. Today, my co-counsel and I seek for the court to strike down the New York Sullivan law. In doing so, the court will uphold and principally extend the right of a law-abiding person to a handgun license outside the home under the Second Amendment protection.
Thank you. I'll now begin the 10 questions for oral argument. What does the Second Amendment protect?
Under the established precedent of Heller, The Second Amendment protects the individual right to possess a firearm unconnected with service in the militia and to use that arm for traditionally lawful purposes, such as self-defense within the home. In brief, it secures the inalienable right of firearm possession for the people's protection. No matter the location, all citizens are entitled to their right to self-defense under the court's previous Heller interpretation, and it is vital that the court continue to uphold this definition.
Thank you. Why did the framers include the Second Amendment in the Bill of Rights?
The inclusion of the Second Amendment in the Bill of Rights is to codify the pre-existing right of self-defense under the constitutional protection. Prior to even the Second Amendment's legislation, the concept of militia holds long-standing history in English common law as a precaution against the fear of European standing armies. More significantly, the duty of the militia has enshrined the right of all citizens to the utilization of arms in the name of public defense. In an effort to uphold this principal right, the framers established the Second Amendment to fundamentally protect the former right of the militia in American law.
Thank you. What are the limits of the Second Amendment's protections?
Under Miller's designation, the court has recognized that the Second Amendment's protection is solely extended to weaponry that's strictly tied to militia purposes because it's the precedent clause of the Second Amendment. But since then, the court established that unusually dangerous or unusual weaponaries are unsecured by the Second Amendment. The court also continues to uphold under Heller that long-standing prohibitions on the possession of firearms by felons and the mentally ill, meaning certain people recognized who has the intention of hurting others must be prohibited from keeping arms. Additional prohibitions are also recognized in Heller, such as the forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or imposing conditions and qualifications on the commercial sale of arms.
Thank you. What does the term arms include?
Taken literally at the time of the founding, the 1773 edition of Samuel Johnson's dictionary has denoted arms as weapons of offense or armor of defense, withholding any mention or indication that the term arms is connotative of military weaponry. This definition has preserved in common day, or under United States versus Miller, we are not limited to founding era technology and continue to designate arms as all weaponry in common use at the time, with the exemption of the designated dangerous or unusual weapons like that used in the military, which are not protected under the Second Amendment's jurisdiction.
Thank you. What is the difference, if any, between the verbs keep and bear in the Second Amendment?
Again, in reference of Samuel Johnson's dictionary, the term keep at the time of the founding is defined as to retain, not to lose, or to have in custody, and similarly referenced to bear as the ability to carry. In consideration of the founder's definition of the terms, the right to keep and bear arms is therefore equivalent with the American individual's right to have arms in one's possession and carry them for the Second Amendment's fundamental purpose of self-defense, fully independent from militia service.
Thank you. What is a militia, and why did the framers refer to it in the Second Amendment?
In historical context, the term originated in response to the Federalist fear of standing armies, and therein, at the time of the founding, the concept of militia would constitute any citizen willing and able to wield a firearm in the name of public defense. In the practice of militia, arms ownership remained the primary duty of the citizenry or the citizens in arms, and therefore the Second Amendment codifies this inherent right as the principal protection of the people. Under Heller, the court recognizes that the framers established a preparatory clause announces a purpose, but does not, notably, limit or expand the scope of the operative clause. In line with this interpretation, the inclusion of the militia in the Second Amendment is an effort to clarify that the uninfringible right of all citizens and bear arms is inextricably correlated with the foundational militia interests in the security of the free state. Thus, in accordance with its original jurisdiction, all citizens of the free state are entitled to self-defense through the carrying of arms.
Thank you. How should courts determine if a gun control regulation is considered long-standing?
Yes, the definition of long-standing holds the obvious significance of prohibitions that have been established since the pre-founding or the founding era, which the court continues to uphold in modern day. Historically, the long-standing comprehension of the Second Amendment is the right to keep and bear arms in the public defense. However, its fundamental protection may in turn be regulated by, for instance, the long-standing limitations against possession by recognized criminals or patients of mental illness. These are the standards which have been upheld continuously since the legislation of the Second Amendment under continued court precedent, and thus they are recognized as long-standing accordingly.
Thank you. What is strict scrutiny, intermediate scrutiny, and rational basis review?
The levels of scrutiny, according to Jimenez, are determined by two factors of how close the law comes to the core of the Second Amendment right and the severity of the law's burden on the right. So in the context of Heller, Jimenez challenged that DC law substantially burdened a lawful citizen's Second Amendment right and consequently passed intermediate scrutiny. So within this case, the law is a deeply exclusive regulation for the average law-abiding citizens, and it directly impacts the core of the Second Amendment, which is the codified right of every person to keep and bear arms for self-defense. The fact that under this law, a law-abiding citizen who has a motivation for self-defense can't obtain the necessary permission to protect themselves in public, and it's directly and severely impacting the core of the Second Amendment right. Under New York's discretionary standard, law-abiding American citizens are clearly prevented from exercising their constitutional right, and therefore there is a compelling interest to be pursued in the law. The case implies some level of heightened scrutiny in consideration of the standards of scrutiny applied in Heller. Heightened scrutiny is implied as the law fails to be constitutional, and the government has a compelling reason to strike down the law.
Thank you. Is there a difference between open carrying a firearm and concealed carrying a firearm?
Certainly, there are differences between the two. Even under Heller, the court acknowledges the long-standing limitations of the Second Amendment, where just as the court's opinion should not be taken to cast doubt on long-standing judgments, such as on the possession of firearms by felons and mentally ill, or forbidding the carrying of firearms in sensitive places such as schools and government buildings, or imposing conditions and qualifications on the commercial sale of arms. The concealed weapons prohibitions that have been upheld under the amendment or state analogs also retain long-standing precedence in the court of law and how arms are carried to this day. However, while the court acknowledges that concealed carry restrictions are potentially constitutional, the New York for-cause law isn't. As it's currently written, it's too burdensome on the fundamental liberty, and is now not narrowly written enough for law-abiding citizens to exercise their right. Therefore, although the Second Amendment does not go unlimited, its fundamental liberty to keep and bear arms shall not be infringed.
Thank you. How should the court consider the public safety implications of licenses to carry firearms?
It is paramount that the court recognize the public safety restrictions which the New York law imposes on the general public. Under the Second Amendment's protection, the petitioners as law-abiding citizens with a severe interest in exercising their constitutional right to keep and bear arms are fully entitled to the licensed practice of their fundamental right. the New York legislation is depriving them of this liberty. The right to self-defense is same outside of and within the home. Under the extended logic of Heller, it's senseless to say that the right to self-defense stops once the person leaves the home, because the gun license requires a good moral character of the applicant. The licensing officer frequently turns down the applicants in the reasoning of no good cause exists, principally violating their Second Amendment right.
Thank you. Any final comments? Thank you, counselors. This concludes our video.